We're on question 3 from the July 2023 California Bar Exam. This is the third essay in the 3-hour block that you're given on Tuesday morning. If you have run over on essay 1 and essay 2, then you wind up with 40 or 45 minutes for this third essay. Look at this one. Answer according to California and ABA authorities, and it asks about ethical violations. This is a pure PR essay, and the grading on this is pretty stringent. So you really need the full hour. Don't let the novice problem happen to you on the bar exam where you shortchange yourself in time for the third essay, because often it's a racehorse like evidence, or it's something crucial like a full-blown PR. Leave yourself the full hour. What do we have here? We know it's pure PR, and we look at the top and it says Laura is general counsel for Moorhome Mortgage Company, a California corporation. Okay, we have general counsel for a corporation. The most common thing that happens in a fact pattern like this is that an employee or an officer comes to Laura and essentially opens a lawyer-client relationship with her, and now she'll be in an irreconcilable conflict between her duties to the corporation and her duty to the individual. Eric is an entry-level mortgage advisor at the company. That's what they're setting up here. So let's look at the law. I'm going over to Proponics. I'm going to open up the general professional responsibility schema, the one with the ABA rules. I want to look at a summary of the ABA model rules. I need to go to client-lawyer relationship, and within that I need to find the rule for organization as client. In our schema, that's under other general rules, because it's a more specific rule than the basic rules on duties. So the first point you see there is organization as client, and we're going to find the basic law that you're going to need to start this answer right here. That a lawyer retained or employed by an organization represents the organization. And so your primary loyalty is the best interests of the organization. You have to explain the identity of the organization as client whenever you're dealing with an individual constituent of the organization. Then, notice the third point down. Measures a lawyer shall take when a person associated with the organization will violate a legal obligation, when the lawyer knows that, and cause substantial injury to the organization. So we've got counsel the person to reconsider, advise the person to get a second legal opinion, refer the matter to a higher authority in the organization, all the way up to the highest authority if necessary. And then finally, the attorney may resign from representation, but may blow the whistle only if necessary to prevent substantial harm to the organization. Now, the problem with that is that California differs in that final prong, that final step about blowing the whistle. So often this kind of PR fact pattern will give you a scenario where you need to get to that fourth step, blowing the whistle, so that you can discuss the difference in law. We'll see if this one does. Back to the hypothetical. Next paragraph tells us Eric approached Laura and gave Laura a package of documents that he obtained through his position at Moorhome. Now I'm worried about whether that packet of documents is evidence. It looks like Eric may be asking for legal counsel from her, in which case he is arguably creating a lawyer-client relationship. The documents demonstrate that Moorhome employees are falsifying the financial history of many mortgage applicants, so they can qualify for mortgages they could not obtain otherwise. The documents also show that it is Morehome's policy to push risky mortgages onto unsuspecting customers. Okay, so they're committing fraud by altering documents, and this is really risking harm to the corporation, and that final sentence gives you that significant harm. So now we have an individual who has arguably set up a lawyer-client relationship with Laura, discuss what it takes to form a lawyer-client relationship. And you see in the next paragraph, Eric confided in Laura. He's giving Laura confidential information, which helps you to form that attorney-client relationship right there. That he was troubled to have learned of those practices himself and wanted Laura's legal advice on what to do. There's a typo there in the bar's hypothetical. It should say what to do. Okay, now, Eric said that he has never engaged in these practices himself, and he doesn't want Meanne, Morehome's chief executive officer, to learn of their discussion. Laura told Eric she would think about it and get back to him. Eric left all of the documents with Laura as she requested. All right, he has provided this attorney with evidence of a crime, and she accepted that evidence. What should she have done at this point? Right here, she breached an ethical duty by not immediately explaining and clarifying to Eric, when he asked her for advice, that her primary loyalty is to the best interests of the corporation and not to him as an individual. In failing to do so, she allowed to be created a lawyer-client relationship between herself and Eric, and now she's in an irreconcilable conflict between the best interests of the corporation and what Eric wants from her, and she's risking a breach of confidentiality if she discloses anything he's said. She's going to think about it and get back to him? No, she has an obligation to go up the chain to stop this conduct. Lots of issues here already, and we're only halfway through the hypothetical. Next paragraph says Laura knows that the practices shown in the documents and described by Eric constitute a crime under state law. So yeah, this is significant harm to the corporation if this continues. Laura also knows that the state attorney general is aggressively investigating similar practices by mortgage companies in the state, although Laura is not aware of whether Morehome has been identified as a target for investigation. So, now she's got a real problem, doesn't she? She's required to go up the chain. Under ABA rules, she may blow the whistle, but if she blows the whistle not knowing whether they're a target for investigation, she's further endangering the organization. So they've set up quite a problem for this attorney. And you can see it coming. She's not going to be able to effectively go up the chain. Okay, what do we have next? Immediately after Eric left Laura's office, Laura called Meanne and informed her of Eric's visit and about Eric's concerns. Okay, there you go. Now, the irreconcilable conflict has resulted in a violation of her obligations to Eric. She would say that she's acting in the best interests of the corporation here, but point out that she lied to Eric when she said she would think about it, and that because she formed an attorney-client relationship with him by failing to clarify her obligation to the corporation as paramount, that she now has violated her duty of confidentiality to Eric. The conflict is fully ripe, and she cannot serve both clients at once. So that raises the issue of withdrawal. Look at all the issues already without finishing this paragraph. You needed to discuss how an attorney-client relationship is formed. You needed to discuss concurrent conflict of interest. confidentiality, withdrawal, and of course, what we already discussed, organization as client, and what to do to move up the chain when there's a problem. But it goes on. It says, Mian instructed Laura not to do anything with the documents and to give them to Mian. Okay, going up the chain has not worked because now the CEO is advising her to assist in a crime, arguably. And right there with that, they've given you the opportunity to discuss whether she has the option to blow the whistle. That raises the distinction between ABA and California, so let's take a look at that rule in California. Back to proponics, to the California rules, and let's look at the major distinctions from the ABA model rules and see what we can find about differences when you're corporate counsel. So I look at client-lawyer relationship, and I'm going to want to go to other general rules. No, I think not there. I think it's under conflicts. And here we have organization as client, when lawyer discovers wrongdoing. And look at the California rule. California does not allow a lawyer to blow the whistle outside the organization. California is much more stringent about confidentiality than are the ABA rules in general. So that one's important. And of course, we raised the issue of withdrawal. So look at the California rule on withdrawal right there. Shall not withdraw before taking reasonable steps to avoid reasonably foreseeable prejudice to the client's rights. And so you might have time to include that kind of rule in your answer. If you didn't, I don't think that's going to cost you points on this one. There's too much going on here. A PR hypothetical will generally give us a distinction from the ABA, and I think that's the big one here on blowing the whistle. So move on with the hypothetical. It says Laura consulted with outside counsel. She can do that without violating confidentiality, right? And you might want to say that, regarding what to do with the documents. And based on that advice and against Mian's instructions, Laura provided copies of the documents to the state attorney general. So there, they allowed you to show that you know that the ABA would be fine with that. That's within the ABA rules, but it is not okay in California. So there's your big California versus ABA distinction for this hypothetical. I think this was jam-packed with issues. As I said at the outset, it would take the full hour to answer this hypothetical. And as always in PR, getting a high score is more than a matter of going down a checklist of rules. It's a matter of showing the grader that you understand what the concurrent conflict was that gave rise to the lawyer's problems that resulted in rule violations. There is a PR essay on virtually every California bar exam. Over 96% of the time, there's either a full-blown PR essay or there's a PR crossover with another subject. So this is an area you are going to need to know really well so that you can deal with it. It's, for me, a difficult one to organize, made much easier if I center my answer around that concurrent conflict of interest that's there in the hypothetical. Often it's that the attorney needs to make money. This one is not like that. This is an organization as client one.